Part 3, Industrial and Labour Law Audit. Industrial and Labour Law Audit is an effective tool for compliance management of labour, employment and industrial laws. Labour Law Audit is useful in promoting cordial relation between employees and employer and also lead to better governance and value creation for the business. Scope of the Industrial and Labour Audit. The Labour Law Audit covers all labour legislations applicable to an industry or business or any other commercial establishments where an audit is being conducted by the Labour Law Auditor. Will certainly differ from the business to business. Labour Law Audit is a unique concept and differs from other compliance or audits in the country. Labour Law Audit considerations of human values and rights of the workmen. The scope of the secretarial audit also includes examining and reporting on whether the adequate system and process are in place to monitor and ensure compliance required under various industrial and labour laws. First, Factors Act. First question, for all the acts we can write act name is applicable to the company. So, Factories Act 1948 is applicable to the company. Next, fifth point, the company has complied with the provisions of first, health, safety, welfare, working hours, employment of young persons and annual leave with the wages. Next, registers and returns and abstracts. First, register of compensatory holidays, means holidays given but with the compensation, that register. Register of adult worker, registered of leave and wage register, master roll. Master roll means for wage labourers daily payment will be now how much they have been paid for or how much they have been worked throughout the day, that register, master roll. Next, register of accident and dangerous occurrences, inspection book, half yearly returns. Next, Industrial Disputes Act 1947. First point, whether this act is applicable to the company. Next, is there any industrial dispute? Next, the company has maintained the master roll as per the required section 25 of the act. And directly go to point 7. The company is a public utility service if as the lockout, if any, has been carried out after giving the sufficient notice. Next, point 9. The company maintains a master roll for its workmen and the company has compensated for being laid off, means from being removed, the workman whose name in the master rolls and has completed not less than 1 year of continuous services. The company has compensated the workman in case of closing down of undertakings. Next, Payment of Wages Act. Is the act applicable to the company? Next, point 3. The deductions made from the wages of the employees. Next, if any deduction has been made on account of damage or loss. Next, deduction has been made for unauthorized absence or after opportunity of being heard is given. Next, Minimum Wages Act. Is the act applicable? The company has been paying the minimum wages as notified from time to time. The company has been paid in wages in cash or in kind and the company follows the conditions prescribed in regarding to working hours, working day under the section 13 of act. Next, the fifth point, the company has paid overtime rate as prescribed and the company has maintained all registers and records. And ninth, the company has followed time and conditions of payment of wages. Eighth, the company has followed the procedure prescribed in Rule 21 of Act rules. Next, Employee State Insurance Act. Is the act applicable to the company? The factory or establishment to which the act applies has been registered or not. And fifth, the employer has maintained the register of the employees. And sixth, the submission of the return or report, annual return, return of contributions, return of accidents, report of death of insured persons. Next, the benefits which are made available to the applicable employees. Next, Employees Provident Fund and Miscellaneous Provisions Act. The Employees Provident Fund and Miscellaneous Provision is applicable or not on the company. If applicable, next go further. The contribution made by the employer and employee and payment thereof in accordance with the rules. The employer has been obtained a declaration from the persons. And fifth, the employer has sent to the commissioner first consolidated return, monthly return. And go to sixth point, the employer has furnished particulars of the ownership to regional commissioner. Seventh, the employer has forwarded the monthly abstract to the commissioner. Eighth, consolidated annual contribution statement was sent to commissioner. So, first employer has sent to, fifth point was consolidated return, monthly return to the commissioner. Sixth, seventh, eighth is first employer is furnished particulars of ownership and employer has forwarded monthly abstract and consolidated annual contribution statement. And next, contribution card. And tenth, any proceedings under the act have been initiated against the directors, if any. 11th, if the employer has created its own trust, whether the terms of the trust are more beneficial than to provided for the trust, means for beneficiary should be more benefiting rather than for personal use. Next, the conditions imposed by the commissioner for creation of the trust are satisfied. And next, payment of bonus act. The payment of bonus act is applicable to the company. In Contract Labour Act, 3 persons responsibility is discussed. First, principal employer, and contract labor and contractor. So first, principal employer. Point number 2, the principal employer has obtained the certificate of registration for the establishment. And point 10, the principal employer maintains the register of the contractor. Point 11, the principal employer has sent annual returns to the registering officer. Point 12, the principal employer has within 15 days of the commencement of the completion, within 15 days of commencement or completion of each contract, submitted return to the inspector. Next, contractor. Point 4, whether the contractor has obtained the license from licensing authority. Point 5, contractor have got their license renewed in time. Point 6, contractor are employing workmen as per the license and registration certificate. Point 7, number of workmen actually employed by the contractor tallies with the number of workmen showing in the license. And point 8, contractors are sending half yearly returns in time. Next, contract labor. 16th point, the contract labor is provided with the facility of restroom, canteen, washroom, first aid and other facilities. 17, contract labor is granted leave with the wages. 18, contract labor is being paid overtime at a double rate. And point 21, payment of wages to contract labor is made within the according to the provisions. And 23, the gate pass to the contract labor are issued and signed by the company's employees. And at last, under this act, under the Contract Labour Act, registration certificate before appointing the contractor, and register of the contractor, register of the employees employed by the contractor, master roll, deduction register, advance register, notice regarding rates of wages, display of the act rules, half yearly return and annual returns by the principal employer. Next, Maternity Benefit Act. Is the act applicable to the company? The employer has knowingly employed a woman in any establishment during the 6th week immediately following the day of her delivery, miscarriage or medical termination of her pregnancy. Next, third, any pregnant woman has made any request not to give her any work relating to that disclosure. And payment, point 4, any woman employee is entitled for maternity benefit, medical bonus, nursing break, and if yes, whether the payment has been made and nursing break was allowed. And point 6, whether the employer has maintained master rolls, registers and records as prescribed, whether the employer has submitted annual returns. And last, whether the employer has submitted annual return. Next, Child and Adolescent Labour Act, whether the act is applicable to the company. The occupier has sent notice to the inspector when a child is employed or permitted to work. And third, the employer has employed any child labour in occupations according to the provisions of the act, and the employer has maintained the register in respect of the children employed or permitted to work, and the occupier has displayed a notice containing abstract of the provisions of this act. If 100 or more workers are employed or were employed on any day preceding 12 months, then this act applies. And the industrial establishment has submitted to certifying officer 5 copies of the draft standing orders proposed by it for adoption in the establishment. The text of the standing orders as finally certified has been prominently posted by the company in English and in language understood by the majority of the workmen as specified by the board to be maintained for this purpose. The industrial establishment has modified the standing orders on agreement between the employer and the workmen or a trade union or other representative body of the workmen. Next, 6th, a workman was suspended by the industrial establishment for pending investigation or inquiry into complaints or charges of misconduct. The industrial establishment has paid any allowance to suspended employee. And next, Employee Compensation Act, whether the act is applicable to company. Point 2, any personal injuries caused to an employee by an accident If yes, the company has paid the compensation. And third, the company has maintained notice book in its premises for reporting notice of accidents. And fourth, the company has reported of fatal accidents or serious bodily injuries. Fifth, the company has deposited compensation with the commissioner in respect of the workman whose injury has resulted in death. Sixth, the company has furnished a statement while depositing compensation. Seventh, the company has sent a return to compensation paid during the previous year. Eighth, on settlement of compensation amount in between company and the workman, company executed a memorandum of agreement with the workman, and such agreement along with an application sent to register it to commissioner. And next, Equal Remuneration Act, whether the act applicable. And second, the payment of equal remuneration has been made to all for same work or work of similar nature, and there is no discrimination between men and women while recruiting or subsequent to recruitment. The company has maintained the register. And next, Employment Exchange, compulsory notification of the vacancies act is act applicable. And second, the company has notified the vacancies to Employment Exchange. And third and the last, the company has furnished quarterly returns. Thank you.